Hello everyone and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I hope you enjoy this legal education content, and today is the day I earn that subscription. For today's story, we are dealing with a decision in which qualified immunity was denied because the person who was not acting within the scope of his official capacity. This is an often forgotten part of qualified immunity doctrine. In order for a person to be covered by qualified immunity, they have to be acting within the scope of their official role. If they're not acting within their scope of their official role, then not so much with qualified immunity. And the problem is that the Texas City Fire Department didn't have the authority to do what they did, so the qualified immunity didn't make sense. So we're going to review this case that just came down from the Fifth Circuit, so let's get started with this. Wendell Willie, nice name, is the captain of a Texas City Fire Department. Zane Sweden and Michael Stefik worked for Windsor as an emergency medical technician. They drove the ambulance to Texas City for a routine pickup at a nursing home. Unbeknownst to them, Windsor no longer had a permit, so driving in the city for this routine pickup would violate a Texas City ordinance. Sweden and Stefik parked their ambulance outside the nursing home and went inside to get a patient. Willie was driving by the fire department vehicle when he spotted the Windsor ambulance parked outside. He knew Windsor was permitless, so he pulled in to investigate, which just meant snapping a few pictures of the ambulance. Around this time, the people came out with their patient. Once the patient was inside the ambulance, Willie pulled up and asked Sweden and Stefik some questions about who they were and where they were headed. They declined to answer, citing patient confidentiality. Then Willie said they'd let them complete the trip before talking with him. Off they went to drop the patient off at a dialysis clinic. During the drive, Willie called the fire marshal and asked them to come issue citations. The drivers parked under an awning outside the clinic. Willie backed up into a spot near the front of the ambulance. The fire marshal had not yet arrived when the drivers finished their drop-off. As he loaded the stretcher into the ambulance, Willie approached them, and here's the kicker. Okay, so this guy says, "You are detained. You're not allowed to leave. You must wait right here." He has placed them under arrest. This is a problem. Yeah. This struck them as bizarre. A man in a paramedic's uniform driving a Texas City Fire Department vehicle detained them in a city other than Texas City. That too, he's probably out of whatever jurisdiction he had in the first place. On the one hand, they knew he was not a police officer. On the other hand, they didn't know, nevertheless, whether they had the authority to detain him. I mean, how would you? But yeah, not going that great. Since his arrest, no, but yeah, nice for playing. They ended up waiting around and submitting to Willie's apparent show of authority. Sweden finished some of the paperwork for the transfer they just completed. The other guy called a supervisor at Windsor to try to talk with Willie, but Willie told them to stay in the ambulance and wait for the fire marshal. Sweden recalls that Willie was rude and told them to get back in the vehicle. They waited there until the fire marshal showed up. They asked him a few questions, gave him the citation, and then they went on their day. Okay, so Willie knew he did not have the authority to detain them. He called the fire marshal because he didn't even have the power to issue the citation. But because he maintains they were free to leave whenever they wanted. No. But by his telling, he identified himself as an EMS supervisor, sat in the vehicle while they waited, and never displayed a weapon or used any physical force. Subsequently, they sued under 1903, alleging unreasonable seizure. We were arrested by a guy who doesn't have the power of arrest. Yeah. The court held that even if there was a genuine issue of material fact, the law was not clearly established. So the trial court went with clearly established as their initial idea. But the Court of Appeals is not going to have that, because the problem isn't qualified immunity. The problem isn't he's acting in his official capacity at all, because he's well outside his depth. Qualified immunity protects government officials acting within their authority from individual liability when their actions could reasonably have been believed to be legal. Once a government official establishes the conduct was within the scope of his authority, it's up to the plaintiff to show that violated the constitutional right and it was clearly established. The first part of the rule often gets overlooked. To even get into the qualified immunity framework, the government official must satisfy the burden of establishing the challenged conduct was within the scope of discretionary authority. The oft overlooked threshold requirement is positive here. To figure out whether an official was acting within the scope of duties, we look to state law. Willie was not acting within the scope of discretionary authority because state law does not give a permit officer the authority to conduct stops of any kind. In fact, state law says the contrary. Texas law criminalizes a public official's act of intentionally subjecting a person to seizure that he knows is unlawful. Willie intentionally subjected them to seizure, and Willie admits that he knew that he had no authority to stop them. So he violated the law. He committed a crime. So not so much with the qualified immunity. Thus, that brings us to the end of this decision from the Court of Appeals for the Fifth Circuit, which ruled against qualified immunity, using a factor that's not often used. The fact that they were not acting within their official scope at all. And the fact that he apparently knew that. And he told people that he knew that. So as always, confession went against him. But yeah, he detained people knowing that he didn't have the authority to detain in violation of law. It was not within the scope of his duties. He didn't have an authority to issue the citation, and he was acting way outside of his depth. So yeah, so you can sue him for his violation because there's no qualified immunity because he wasn't acting within his role. So qualified immunity takes a little bit of a rest on this fact pattern, and at least for the moment, that brings us to the end of the discussion of this case.